Good morning to all of you. Yesterday, while discussing the topic of human rights, I told you in the ICCPR, a right to fair trial, a right to speedy trial, they are also coming under the fundamental rights envisaged in Article 21 of the Constitution of India. So Article 21 basically it says about the right to life and liberty. This is a point in liberty. So right to liberty, Supreme Court has categorized almost 27 rights which I have told you, and out of them right to fair trial and right to speedy trial is the fundamental right. Right? Even according to 309 CRPC, what does it say? 309 CRPC says the case, when once the trial is started, it should be adjourned as expeditiously as possible. Particularly when the witnesses examination started, that is the stage. So when the examination of witnesses started, definitely it should be done adjournment by adjournment. The quick adjournment should be there and the trial should be completed as expeditiously as possible. Right? So as expeditiously as possible you have to underline. That means as quickly as possible. So far as the time permits. There may be so many other factors. Now suppose even though they want to conduct it as fast as possible, the COVID-19 will not allow you to appear before the court except by the so-called virtual, which is not that easy. Right? So here now we are going to discuss a case where the Honorable High Court of Madhya Pradesh, Gwalior Bench, Justice G.S. Ahluwalia, Ahluwala, Ahluwalia, normally you pronounce it as Ahluwalia. So he held that the state cannot claim sovereign immunity in not conducting the trial in time. Right? It cannot be a sovereign immunity. So once again we have to get back to our Magna Carta 1215 British or Crown Proceedings Act 1947 or Article 300 of the Constitution of India, where the state is liable for the acts done by its servant. No sovereign immunity, that's gone. They are the olden days, sovereign immunity is not there. So if anybody does the work in the discharge of official duty, the government will come to his shoulder or to take up the responsibility. That means sanctions under 197 CRPC. Sanction will be given for prosecuting the person. If the government does not desire, then they will not give any sanction. Anyway, we are diverting to the other thing. Now we can say that here what happened is we are going to discuss a case where the failure on the part of the state, the failure on the part of the police department, the failure on the part of two inspectors of police in attending the court for deposing their evidence, it has made them costly, and now they were supposed to pay an amount of rupees 20,000 as compensation to the accused person who is languishing in jail. Now, coming to the facts of the case, the petitioner was arrested for the offence under Section 8, read with 20B of the NDPS Act, Narcotic Drugs and Psychotropic Substance Act. Maybe for Genza or heroin or something, he was found in possession of the same, he was arrested. Right? So, the FIR was registered against him, the investigation was completed. Please remember, only 3 witnesses. Right? The charge sheet has been filed, he is in the jail. Now, even though the charge sheet has been filed about 1 year back, only one witness, maybe the sub-inspector or the SHO of the police station, he was examined, and 2 inspectors of police have to attend the court. For their purpose, the case is being adjourned from 2 dates, that is 26/3/2019 to 3/4/20, almost 1 year. So for the past 1 year, these 2 inspectors, one they are Ramesh Paul Yadav and second is Rekha Paul. So the Ram Naresh Yadav and Rekha Paul, both of them did not attend the court for the past 1 year. Right? So the adjournments are being given. Of course, the Honorable High Court held that even there is no representation. Though normally the court will be adjourning the matter next time. After 2 or 3 adjournments, they have given the summons also. Summons were not served. Then the next step, they have given the bailable warrants. They were also not executed. Besides not executing, there is no information on the particular date of adjournment, whether they were executed or not, whether the officers are available or not. Right? This is the position. Very pathetic condition of the state of affairs of the police department. No mention. Then secondly, the investigating officers, this Yadav and Rekha Paul, even they did not file any application with reasonable grounds, saying that because it is the primary duty of the police to maintain law and order. Is it not? So some urgent emergency work is there, we will adjourn on the next adjournment, we will come on the next adjournment. Like that, at least they should have filed a petition. No such petition has been filed. In spite of all these things, the case is being adjourned from time to time. 1 year has passed. He filed bail applications, continuous bail applications. In the 8th bail application, since the trial court did not entertain his bail, then the matter came to the single judgment of Gwalior High Court, and the Gwalior High Court Justice G.S. Anulia, after going through the entire record of investigation and entire file, then he stated that the state, that means police department, cannot take sovereign immunity in cases of violation of fundamental rights. So, right to speedy trial, it is a fundamental right. But this fellow, this accused, has been languishing in the jail for more than a year without any progress in the trial. This is completely attributable to the police department. So, right to speedy trial is a fundamental right under Article 21 of the Constitution of India. Now what he has written: the state cannot seek immunity in violation of the fundamental rights. The court is of opinion that it is a fit case where the state can be saddled with the liability of payment of compensation to the applicant who was in jail. Now go back to our law of torts. So the compensation when the fundamental rights are violated, that is Article 32. You can go to the High Court under Article 226 and definitely you will be compensated. Right? Now, so it is a fit case there. And of course, as far as the police department is concerned, they also commented that the police, instead of giving paper circulars, that means normally the DGP will say, we have been instructing our people all these things. So instead of issuing paper circulars, it must take effective action in the matter. Of course, the court does not want to interfere in the internal affair of the police department. Of course, they asked these people to conduct departmental inquiry as to why the police officers failed to attend the court on the particular dates of adjournment consecutively. Because the court is of opinion that they are deliberately avoiding to appear before the trial court and they are taking it granted. What happens? It will be adjourned some other day, will come coolly go on some other day. So the circle inspectors, both the circle inspectors, they are not concerned about the life and liberty of an under trial prisoner. This is most important. Under trial prisoner, and they did not even file a memo before the court with grounds, that is reasonable grounds. So they have taken the trial for granted, right? So the officers, police officers, should not be permitted to stay away from the court because it gives a ground for them to get bail, is it not? So since due to the absence of the officers, definitely since the trial is conducted, the court can grant bail. But here what happened is the court dismissed the bail petition and asked the regular trial court to conduct after the resuming of resume of the court after that is normal resumption of court after this COVID. They asked the trial court to conduct the trial as expeditiously as possible and dispose the case. In the meanwhile, they were given the compensation of 20,000. These inspectors have to pay. It will be cut from the salary of the so-called inspectors. So please remember, this is the value of the human right. Please take it a good example and you can make your case also if necessary. Thank you.